Everyone, welcome back to the channel. My name is Varun Kaushal and I am a legal intern at LEXIS and Company. Today we are going to discuss about doctrine of precedent. A decision that has already been taken by a higher court is binding to the lower court and at the same time stands as a precedent to the lower court judgment which cannot be altered by a lower court. This principle is known as stare decisis, which is derived from the Latin phrase stare decisis et non quieta movere, which means to stand by the decided matters. In India, it is commonly known as the concept of precedent. As per Black Law's dictionary, stare decisis means to stand by decided cases, to uphold precedents, or to maintain former adjudications. As explained by Professor A. Lakshminath, the doctrine of stare decisis helps to generate judicial accountability. Along with it, it also ensures fairness in adjudication and excludes arbitrariness and helps in maintaining stability and certainty. Professor further explained that stare decisis is both a social as well as a legal norm. Now I will tell you about the historical background of this. The desire for certainty and continuity in law gave rise to the doctrine of stare decisis. This doctrine was initially used in medieval England and America, where the common law courts looked into the judgment of earlier cases as guidance. Also, they had the power to reject those which they do not consider good or which they considered bad. Initially, due to the lack of recording the decisions or judgment cases in written form, the doctrine of stare decisis was not freely used, but after the concept of recording the judgment came, widespread use of this doctrine was witnessed. It was in the 17th century for the first time in England. The decision of executive courts was given a binding force. Later in 1883, the urgent need for recognizing the binding force of precedents was brought into notice in the case Myhouse versus Rennell. Further, in 1873 and 1875 came up the Supreme Court Judicature Act, where the theory was stare decisis was established. In India, the concept of precedent established after the Britishers came to India, which lead down the hierarchy of courts and the concept of higher courts judgment binding the decision of the lower courts. In 1935, the Government of India Act explicitly mentioned that the decision of federal courts and Privy Council will be binding all the other courts' decisions in British India. Hence, from the 18th century till date, stare decisis is a characteristic feature of our legal system. Article 141 of the Indian Constitution states that law declared by Supreme Court to be binding on all courts within the territory of India. Article 141 states that only the ratio decidendi of a case is binding, not the obiter dicta and the mere facts of the case. Therefore, while applying the decision of Supreme Court by other courts, what is required is to understand the true principle laid down by the previous decision. There are some types of precedents. Number 1, original and declaratory precedents. Original precedents refers to those cases where there is a question of law that has not been decided before, and then in such case the decision of the judge forms originally. An original precedent is a law for the nature which creates and applies new rules. Declaratory precedent means those cases where the application of an existing rule of law is used. In such cases, it is seen that the rule is applied because of a law already existed on it. Number 2, authoritative or binding precedent. It is also known as a mandatory precedent or as a binding authority. It means those decisions which the judges must follow, whether they approve it or not. It denotes the higher court's decisions that are binding over the lower courts of that region. Persuasive precedent. These precedents are not as binding as the authoritative precedents. These precedents mean that while making any judgment, the judge has to consider these precedents and has to give higher weightage to it. The main concept behind considering it is that it is relevant and can help in making a fair decision. These cases could be which are put at a similar level in the hierarchy of courts. Even lower courts' decision can play a role in persuasive precedent. Decisions that are not considered under Article 141 of Indian Constitution, there is some decision which is not considered as a precedent or which do not have a binding effect. Those are: number 1, the decision that is not expressed; number 2, the decision is not founded on reasons; number 3, the decision that does not proceed on consideration of the issue; number 4, obiter dicta of a case are not binding, hence it cannot be relied upon solely as a ground to hold any statutory rule invalid. It has a persuasive value. Number 5, decision is rendered per inaccuriam is not binding. Per inaccuriam's literal meaning is resulting from ignorance. Hence, any decision made on per inaccuriam is not used as a precedent. Now I will tell you some advantages of precedents. Precedent means to follow the same which has been done earlier. Hence, the first step while considering the precedent is to look at the similarity. If there is any, then the magnitude or degree of similarity that existed between the problems. After this, it has to be seen whether the same has been used before a precedent and has resolved the problem in this manner. The precedent works. Therefore, the advantages our legal system enjoys by this doctrine are: number one, it is time saving, avoids unnecessary litigations; number two, there is an orderly development of the law. It brought greater certainty and consistency in the law, which is the most remarkable advantage. A good decision making body needs to have consistency. Avoid arbitrariness in judgments. It eliminates the element of ambiguity, enables the lower courts to follow the decision of the higher court unanimously. The presence of precedent decreases the probability of a judge making a mistake. It also serves the concept and interest of justice, as giving the different decisions to similar situations might be considered unjust. Now I will tell you some of the disadvantages of precedents. Every good thing comes with its byproducts, which are bad or have a negative effect. Some of the negative effects of stare decisis doctrine are: also, practical law is based on experience. By considering precedent, the scope of experience decreases, which hampers the essence of practicing law. It is being criticized because of its limiting effect on the development of law. The first and foremost disadvantage of this doctrine and the precedent system is its rigidity. Another disadvantage is its complexity, which sometimes makes the situation more uncertain. Many times, judicial mistakes are being continued in the form of precedent. In conclusion, I'd like to say that hence the stare decides doctrines is very helpful for our judicial system, but at the same time, the convenience of following the precedent should not be left to degenerate into just a mechanical exercise performed without any thought. It should be used carefully in the view of promoting justice and equity. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe our channel LEXCLIQ.